All right, I will call the case and make some announcements on the record and then call for the parties' announcements as well at that time. I call cause number 10,810, the case being styled the state of Texas versus LaShondra Delon Richardson. This is a plea hearing wherein the defendant or the court understands that the defendant desires to enter a plea of guilty to the allegations in the indictment pursuant to a plea agreement between defense and state. This hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. It is also being live streamed on the court's YouTube channel in order to provide compliance with the orders from the Texas Supreme Court and the rules and directives issued by the Office of Court Administration. As such, the court directs that and orders that all persons are prohibited from recording this proceeding in any manner whatsoever, whether electronically or using the Zoom or YouTube recording functions or photographically. No portion of this proceeding may be recorded except by the official court reporter who is transcribing this hearing just like he would do if we were live in person in court, which of course we are not because we're using the Zoom protocol as directed by the Texas Supreme Court. With all of those pronouncements being made, for purposes of this plea hearing, what says the state?
State's ready, Your Honor.
And the defense?
We're ready, Your Honor.
Mr. Richardson, just for the record, are you LaShondra Delon Richardson?
Yes, sir.
Mr. Richardson, an indictment has been returned into this court in cause number 10,810, charging you with a third-degree felony offense of evading arrest using an automobile or a vehicle. And there is one enhancement paragraph alleging a previous conviction in 2013 from this court. You have the right to have that indictment read out loud to you here in open court. Do you wish to have someone read the indictment out loud to you?
No, sir.
Do you understand that the indictment that in cause number 10,810 charges you with a third-degree felony offense of evading arrest?
Yes, sir.
And do you also understand it alleges one prior conviction, which if proven true would increase the punishment range from a third-degree felony to that of a second-degree felony?
Yes, sir.
Then understanding the charges to the allegations in the indictment of third-degree felony evading arrest, how do you wish to plead to that charge, guilty or not guilty?
Guilty.
And to the allegation of one prior conviction in what's called an enhancement paragraph, what is your plea to that allegation of a prior conviction? Is it true or not true?
True.
Do you understand that you do not have to enter a plea of guilty to the charge, and you do not have to enter a plea of true to the enhancement paragraph? You have the absolute right to require the state to prove those matters. And further, you have the right to not have it used against you just because you might have exercised your right. Do you understand that?
Yes, sir.
Now, you also have the right to have a minimum of 10 days notice of the charges pending against you. The court is aware that you have had more than 10 days notice of these charges. Nevertheless, I would grant you some additional time to prepare to meet these charges, although I don't want to be I don't want to be misunderstood. We have a jury trial scheduled and a jury summoned to hear your case starting next Tuesday. So you would have at least another week and a day before we would go to trial. Nevertheless, I have a document in front of me entitled Waiver of Defendant that says you're giving up the opportunity to have more time to prepare, even if it would just be 8 more days. You also have the right to have a jury hear your case. And that's true even if you were to enter a plea of guilty. In other words, you could plead guilty to the charge in front of a jury and have them make important decisions. But the waiver of defendant document that I have in front of me now that has the signature, which is the same signature, or looks like the same signature as you identified to the notary public as your signature. And it says you're giving up the right to a jury trial. Did you realize by signing the waiver of defendant document, you were giving up the right to a jury trial and the right to have more time to prepare? So it means your case would be heard by me today without a jury trial. Did you know that when you signed these papers?
Yes, sir.
And is that what you still wish to do?
Yes, sir.
Mr. Keith, your signature is on this document as well. You have not had 10 days notice because you were just appointed last week. And so I ask you, are you joining your client in the waiver of time?
Yes, Your Honor.
And do you feel that you've had adequate time to review the case and to discuss with your client, Mr. Richardson, the charges, the facts that might surround the charges, any offers, and make decisions about how to proceed? Have you had opportunity to do all that?
Yes, Judge, I have had sufficient opportunity. There is one item that I would like to note for the sake of the record, if you permit me. And that is with respect to the enhancement allegation alleged, it occurs to me just now that the prior could be a punishment enhanced third degree rather than a jurisdictional third degree. And I've pulled up on an alternate screen to verify the health and safety code. So I'm looking at the health and safety code at the same time. But I'm having trouble with my screens to look again at the indictment. So I've asked Kayla to send it to me, and I believe that she just now has. So I'm looking at this now. And possession. Judge, I wonder if you follow what I'm trying to confirm or dispel, and perhaps Mr. Smith can shed some light. If the enhancement is indeed a jurisdictional third degree, then so far, Mr. Richardson has been admonished correctly.
Judge, Trey, I have that judgment here. Let me look at it. The prior judgment would seem to indicate that it is a third degree felony that was charged and he was convicted of as a possession of a controlled substance in a drug-free zone.
All right, then provided it's jurisdictional third degree rather than state jail punished as third degree, then I would agree that Mr. Lechandrick has been properly admonished to this point.
That's
So-
that's how the judgment appears.
At least for purposes of, Judge, to answer your question then, I am satisfied that I've had enough time to consider the evidence, the discovery. It was all provided to me on Friday. I was able to visit with Mr. Richardson in person for a couple hours at the jail on Friday. I am waiving any additional time to prepare for trial in accordance with Mr. Richardson's wishes, that he wishes to dispose of his case by this agreement.
All right. Mr. Smith, your signature is also on the waiver of defendant document. Is that evidencing that the state is joining in the waiver of the right to a jury trial?
Yes, Your Honor.
All right, I will accept those waivers and we will proceed. Mr. Richardson, there are other rights and admonitions I need to discuss with you. And let me discuss or start by discussing the range of penalties you face under this indictment. As we have suggested or have been discussing, the offense charged alleges a third-degree felony. The range of penalties for a third-degree felony runs from not less than 2 years to not more than 10 years in the Texas Department of Criminal Justice, the institutional division, and carries the possibility that a fine could be imposed, and if imposed, to be in an amount not to exceed $10,000. Now, as we have also been discussing, there is an enhancement paragraph in your indictment. And if you're convicted of the evading offense alleged in the indictment, and if the enhancement paragraph is proven to be true, then there is a range of penalty enhancement, or it increases to that of a second-degree felony, which carries a range from not less than 2 years to not more than 20 years in the Texas Department of Criminal Justice, as well as having the possibility that a fine could be imposed in an amount not to exceed $10,000. Now I have discussed the possible range of penalties that exist under this indictment. Do you understand that's the possible range of penalties that could exist or that does exist under this indictment?
Yes, sir.
Now, I am aware that a plea agreement exists in your case. I have looked at it. And so I'm aware that it exists and that this hearing is being conducted pursuant to that plea agreement. But I need to tell you also on the record that I do not have to follow that plea agreement. I do have to tell you if I'm going to follow it, because if for some reason I decide not to follow the plea agreement, then a right would then exist in your favor, allowing you to withdraw or take back your plea of guilty. I hope I can say that a little more simply, and I would say it this way. If I don't follow your plea agreement, you can take back your plea of guilty, and if so, we just start all over. And nothing you have signed today and nothing you have said, such as pleading guilty, would be used against you when we went to trial. Now, that's what happens if I don't follow your plea agreement. But if I do follow your plea agreement, then you and the state will be bound by the terms of the plea agreement, and you would not be able to get out of the terms of the plea agreement just because you changed your mind. You couldn't even get out of the plea agreement by appealing your case. Now, ordinarily, a person has the right to appeal even from a plea bargain agreement, but that ordinary right disappears if a part of your plea agreement says you're giving up the right to appeal as a part of the agreement. Your plea agreement, as I looked at it, said you were giving up the right to appeal as a part of the agreement. And so once again, that means if I follow your plea agreement, you cannot appeal at all. Do you understand that?
Yes, sir.
All right, so then let's go further in our plea discussion. And let me ask you some questions I'm required by law to ask. First one of those questions is, are you a citizen of the United States of America?
Yes, sir.
Where were you born?
Snyder, Texas.
Was that Snyder, Texas?
Yes, sir.
All right, sir. My next question asks, do you consider yourself presently to be mentally competent?
Yes, sir.
Do you know what's going on in these proceedings?
Yes, sir.
Have you been able to understand the charges in the indictment and the enhancement paragraphs so that you could discuss those with your attorney and discuss the facts that surround those charges, as well as cooperate with him in planning how to deal with these charges? Have you been able to do that? I think your screen is frozen for a moment.
Yes, sir.
Okay. Have you also been able to hear what your attorney has advised you about what the law is and how the law might affect or be affected by the facts of your case? You've been able to do that as well.
Yes, sir.
And I guess one other matter I want to ask you about, and it kind of fits right here. You previously had an attorney that you were not satisfied with, and I allowed that attorney to withdraw and appointed Mr. Keith to represent you just last Friday in preparation for a jury trial starting next Tuesday. Are you satisfied that you have had sufficient opportunity to visit with your attorney and discuss the things that you thought were important for you to discuss with him before entering this plea of guilty?
Yes, sir.
Are you satisfied with the legal representation that Mr. Keith has provided to you in these matters?
Yes, sir.
And I ask that because I'm not trying to suggest you wouldn't be or shouldn't be. Instead, I ask you that just so you would have a chance to tell me and explain if there were any problems, so that if problems actually existed, I could work to resolve or correct any problems that existed. But I should also tell you that by giving you the chance to tell me if there are any problems in the attorney's representation so I could still work to get them corrected, that necessarily means you're not likely to be successful if you wait to some later date to say your lawyer didn't do a good job. In other words, if you think that, now is the time to tell me. Do you understand?
Yes, sir.
And understanding that, are you still telling me you're satisfied with your attorney's representation?
Yes, sir.
Then let's go to another area for me to ask questions that I'm required to ask. These dealing with your decision to enter the plea of guilty and true. The law says I must be satisfied that you enter these pleas of your own free and voluntary will. And so I ask you, has anybody threatened you or forced you or tricked you or in any other way tried to make you plead guilty when you would not otherwise do so?
No, sir.
Has anybody promised to give you something of value, be it money or anything else that is valuable to you, just to get you to plead guilty when you would not otherwise do so?
No, sir.
Are you telling me then that you're pleading guilty to this charge because the truth is you are guilty of this charge, and that's the only reason you would plead guilty to this charge?
Yes, sir.
All right, sir, those are all the questions I have at this time. Mr. Smith, you may proceed.
Your Honor, the state offers for evidence a document marked as State's Exhibit 1. State's Exhibit 1 being this defendant's signed and sworn stipulation of evidence in this case.
No objection, Your Honor.
Mr. Richardson, this is the document that the notary discussed with you, and I want to discuss it with you just a little bit further. Because there are other rights and admonitions I need to advise you about that are related to the stipulation or kind of fit right here in our discussion. The first one I need to tell you about is this: the state is required to produce some evidence tending to show your guilt. And that's true even if you enter a plea of guilty, because it helps to ensure that another right that belongs to you, we call it the right to confront the witnesses, which really just means you have the right to require the state to bring those witnesses into court so you can see them and hear them as they give testimony under oath. But this stipulation of evidence says you're giving up that right, and thus you're telling the state they don't have to bring their witnesses into court at all. Did you understand you were giving up that right when you signed the stipulation?
Yes, sir.
The stipulation also says you're giving up your right to remain silent and your right to be free from self-incrimination, which is the right to not be forced to give evidence against yourself. And instead, you are giving evidence against yourself because the stipulation of evidence, as it says, is a judicial confession where you admit that all of the material allegations in the indictment and in the enhancement paragraph are correct, that you committed the offense as alleged and you were previously convicted as it is alleged. Did you realize that's what you were doing when you signed the stipulation of evidence?
Yes, sir.
Finally, with respect to the stipulation of evidence, there's a paragraph in there that says that you are aware that there are court costs totaling $290 and there are reimbursement fees totaling $660 in your case. Did you realize that was in the stipulation of evidence?
Yes, sir.
Then State's Exhibit 1, the signed sworn stipulation of evidence is received as evidence in this cause.
State rest, Your Honor.
Your Honor, permit me to call Mr. Richardson for some testimony.
All right.
And
Mr. Richardson, would you raise your right hand and be sworn as a witness? Do you solemnly swear that the testimony you may give in this cause shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. You may put your hand down. Mr. Keith, you may proceed.
thank you, Judge. Chandrik, you and I only met last Friday over at the jail. Is that your recollection?
Yes, sir.
Okay. Did I spend a couple hours, though, with you reviewing videos, documents, and answering your questions?
Yes, sir.
Was I able to answer all of your questions to your satisfaction?
Yes, sir.
And am I following your instructions, joining you in your waiver of your right to a trial, and the waiver of these other rights that we're making in exchange for the terms of a plea agreement that we have with the state?
Yes, sir.
Okay. And the terms of the plea agreement, do they include a dismissal of the companion case for unlawful possession of a firearm by a felon?
Yes, sir.
Okay. And also a potential companion case. Contemporaneously, I believe you were arrested for endangering a child because as you drove on the date of the offense, you actually had your child in the back seat. Is that correct?
Yes, sir.
Okay. The state apparently has rejected or declined to file a separate charge for endangering a child. And you take that to be part of the plea agreement, that you're not going to find yourself suddenly charged with another offense in connection with that. Is that correct?
Yes, sir.
Okay. And so essentially your understanding of the plea agreement is that as Mr. Smith will announce it to the court subsequently, this will resolve all of your cases in connection with the arrest back in, was it April of last year?
Yes, sir.
Okay. All right. There's another thing I want to ask you about. It's related to the questions or the discussion I had with the court and Mr. Smith earlier about the jurisdictional enhancement paragraph. Typically, Mr. Richardson, I would, as I'm preparing a case, I would look at the original indictment and the original judgment that would be alleged as an enhancement paragraph. But I haven't done that. Nevertheless, it is true that you are currently on parole for 2 offenses, correct?
Yes, sir.
You went to TDC at one time for 2 cases. One of those cases is the possession that is alleged in the indictment, right?
Yes, sir.
But you're serving a concurrent sentence for what I call a for real TDC felony. Burglary of a habitation out of Panola County, Texas. Is that correct?
Yes, sir.
And so the upshot of that is, even if there might have been a problem with the jurisdictional paragraph in this indictment, you nevertheless would be subject to the 2 to 20 punishment range if we went to trial and if you should have been convicted and the state simply gave me notice of intent to enhance of the other offense. Do you understand what I'm saying and getting at?
Yes, sir.
And furthermore, does it factor into your decision to make the waivers that you've made? Does it factor into that the fact that otherwise these 2 cases might have been tried separately
Yes,
and
sir.
and subsequently run consecutively if you should be convicted and punished in both cases?
Yes, sir.
So on the whole, I guess you would agree that the terms of this plea agreement are in your best interest. Is that the case?
Yes, sir.
And you're asking the judge to follow the terms of this agreement?
Yes, sir.
Is that all right? Then one last question. Are you satisfied with the representation you received from me?
Yes, sir. I am.
Thank you, Mr. Richardson. I pass the witness.
I have no questions for the witness, Your Honor.
Then the defense rests, Your Honor.
Slate closes.
Defense closes.
All right. Upon the close of evidence, Mr. Richardson, let me discuss the plea bargain agreement with you. I'm looking at that written plea bargain agreement again, and I just want to make sure I understand it the same way you understand it. My understanding is that under the plea agreement, you will enter a plea of guilty as you have done. That will result in a sentence of 10 years confinement in the Texas Department of Criminal Justice, that there will be court costs assessed totaling $290, a reimbursement fee or reimbursement fees totaling $660 will also be assessed. No fine will be assessed, and you will waive your right to appeal. Plus, you will be given time credits totaling 299 days. Then it's not in the written plea bargain agreement that is in front of me, but there is another document that has been presented to me that indicates the additional terms of plea agreement include the dismissal of cause number 10,811, which is one of the cases that Mr. Keith discussed with you in your testimony. And then at least the representation has been made that the state will not file any other charges growing out of your arrest on April 24, 2020, which forms the basis of this, the charge in this case in 10,810. Now, all of that is my understanding of the plea agreements in your cases, or in your case, well, I guess cases. Is that the same as your understanding of the plea agreements in your cases?
Yes, sir.
I'll make a note that there is no provision in the plea agreement for your case to be stacked on any other case that you may now be serving or may have to serve, if there is any. And so that means this conviction, this 10 years, will run concurrent with any other penitentiary time that you are required to serve, if there is any. Is that your understanding as well?
Yes, sir.
All right, Mr. Smith, Mr. Keith, have I stated the plea agreement accurately as you understand it to exist?
It is, Your Honor, but for what it's worth, and I know Mr. Richardson already knows this, Mr. Richardson is facing an additional indictment in Eastland County, and whether the judge should subsequently cause that to be consecutive is not something that you have any control over. But otherwise, yes, sir, you certainly described the plea bargain accurately.
And I tried to use my words carefully. I was not aware that there is another charge in another county pending, but I tried to use my words carefully to say this offense is not to be stacked on any other offense he is presently serving or to be served from a prior charge, prior conviction, I mean. Is that what you're trying to tell me also? Mr.
Yes,
Keith?
sir. Yes,
All right.
sir.
Mr. Smith, have I stated the plea agreement accurately as you understand it to exist?
Yes, Your Honor.
Mr. Richardson, do you want me to follow your plea agreement in this case?
Yes, sir.
All right. I announced that I will accept and follow the plea agreement announced. And so I further announced that in cause number 10,810 for the case style, the state of Texas versus LaShondra DeLon Richardson, Mr. Richardson, based upon your plea of guilty, based upon your plea of true to the enhancement paragraph, and based upon your stipulation, the stipulation of evidence that was received as evidence, I find that you are guilty of the third-degree felony offense of evading arrest. I find that the prior enhancement paragraphs alleged are true. And so I then ask, with those announcements made, do you know of any legal reason why a sentence should not be pronounced at this time?
No, sir.
Then, following your plea agreement, I hereby sentence you to serve 10 years confinement in the Texas Department of Criminal Justice, the Institutional Division. No fine is assessed as per your plea agreement. I do order you to pay court costs totaling $290 and reimbursement fees totaling $660. I also follow your plea agreement and grant you time credits totaling 299 days. With that, let me ask, do you have any questions about this proceeding or any part of it?
No, sir.
Then those will be the orders of the court. Your thumbprint is required on this judgment. And it has now been affixed to the judgment, and we will be in recess. Thank you, Mr. Richardson. Good luck to you, sir.
Thank you.
Take care, Your Honor.
Mr. Keith, could you remain on for a moment
Yes, Your Honor.
with Mr. Smith? I wanted to discuss Mr. Hallman with you. Hallman, I'm not sure how to pronounce it. Our initial plan and discussion was to have him here this week. But the weather continues to override most of our plans.
It has been most vexing.
Yes, Vexing is a kind word for what's going on around the state, weather-wise, I mean, as well as otherwise. And so my thought is to reschedule him and require him to be here next Monday morning prior to trial. I have a jury called, and I'm not going to dismiss that jury until after we see Mr. Hallman. I don't believe this will happen, but I don't want to show up and have him show up and say, oh, now that you don't have a jury standing by, I'm not doing anything. As I say, I don't think that would occur, and especially not from you, but that's my plan. Do you see any problems with that plan?
Judge, I do not, except that idiot. We're not on the record, right? And we're not,
Hold
no,
on.
we can't be on the record.